Can a patient sue because a healthcare entity endured a HIPAA violation? Within HIPAA, there's no private cause of action. Therefore, it's not possible for a patient to take legal action and sue for a HIPAA violation. Even if the HIPAA laws are clearly violated and the patient suffered as a direct result, they can't seek damages. So if it's not possible to sue for a HIPAA violation, how is it possible for people to sue for healthcare providers for exposing their protected health information, or PHI? Does this mean that someone can't take action against a covered entity when it's clear they violated HIPAA? While HIPAA does not have a private cause of action, it's possible for patients to take legal action against healthcare providers. They can obtain damages for violations of state laws. In some states, it's possible to file a lawsuit against a HIPAA-covered entity if they can prove that the provider was negligent or there was a breach of an implied contract. For example, if a covered entity failed to protect medical records, a patient can claim that this was a breach of an implied contract. In such cases, the plaintiff needs to prove that damage or harm happened as a result of the negligence and the theft of unsecured personal information. Let's take a look at a real-world example. Hi everyone, I'm Elia from Tactics, and today I'm going to talk about an example of a HIPAA violation lawsuit. Before we get started, make sure you subscribe to our YouTube channel by clicking the button below. Also, hit that alert bell icon so when we post new helpful content, you get notified. A company we will call Lilly Medical Center for the sake of this video is a 622-bed health system based in Montana. It operates 6 hospitals and more than 68 provider clinics in the state. In February of 2022, the healthcare entity announced that it was a victim of a cyber attack that involved patient data. Lilly Medical Center first detected the breach in November of 2021. Investigators confirmed hackers were in their systems for at least 4 days. In January 2022, the healthcare entity learned that attackers accessed files containing patient information. The data included information like names, addresses, medical record numbers, dates of birth, telephone numbers, email addresses, insurance claim information, dates of service, treating/referring physician, medical bill account numbers, and health insurance information. The healthcare entity soon learned that the breach affected more than 213,500 individuals. As a precaution, Lilly Health Centers offered complimentary credit monitoring services. In the lawsuit filed against Lilly Medical Center, plaintiffs alleged that the company failed to implement reasonable and appropriate cybersecurity measures. Lilly Medical Center did not provide sufficient security awareness training to its workforce. The plaintiffs believe that if there was enough training, they could have avoided the whole breach. The lawsuit alleged that the plaintiffs and the class members have suffered the damages due to exposed PHI and PII. Lilly Medical Center chose to settle the lawsuit and agreed to create a $4.3 million fund to cover claims. Under the terms of the settlement, affected individuals can submit claims and receive a maximum of $25,000 to reimburse out-of-pocket expenses that are reasonably traceable back to the data breach. Claims can also include lost time, up to a maximum of $125 per class member. If you'd like to learn more about HIPAA class action lawsuits, reach out to Tactics. And you've already made it this far into the video, so you might as well like it, share it, and comment below.